the anti-guru.
Picture this. You're scrolling through your feed late at night, and a video pops up.
Oh, I think I know exactly the kind of video you mean.
Right. A driver refuses to roll down their window more than an inch, right? And they're holding this thick stack of, well, pseudo-legal paperwork to the glass.
Yeah, and they're usually confidently declaring to a thoroughly baffled police officer, I am not driving, I am traveling.
Exactly. We have all seen some version of this. I mean, it is a massive internet phenomenon at this point.
Yeah.
But here is the multi-million-dollar question for you listening at home. Do they actually have a point?
Well, it is the absolute definition of internet mythology colliding with, harsh legal reality.
Yes.
Like, those videos are fascinating from a sociological perspective, but from a constitutional standpoint, they represent a massive fundamental misunderstanding of American law.
Okay, let's unpack this. Because today, we are taking a deep dive into a brilliant, comprehensive legal memorandum. It was prepared by Dynamo Jack.
And it really is a fantastic resource.
It is. I mean, this memo is effectively a masterclass in separating that viral roadside mythology from actual foundational United States constitutional doctrine.
Right. And our mission for this deep dive is to explore the true constitutional right to travel and to map out its very real historical boundaries.
Because we want to definitively explain why this incredibly fundamental right does not, under any circumstances, give anyone a free pass to ignore driver licensing, vehicle registration, and basic public safety laws.
Which is a really critical distinction to make early on. I mean, the right to travel is entirely real. It is foundational.
But it has to be properly defined.
Exactly. When somebody weaponizes the phrase right to travel as this, magic incantation to avoid a speeding ticket or a registration fee, they completely miss the profound structural purpose that right actually serves in our country.
And for you listening right now, whether you are a legal nerd or, someone who has stumbled down a late-night internet rabbit hole of sovereign citizen videos or just a curious learner, this deep dive is going to give you the ultimate intellectual toolkit.
It really will. By the end of our conversation, you will understand exactly where true constitutional rights end and, where reasonable state-level safety regulations begin.
Yeah, we are going to look at the history, the mechanics, and the actual Supreme Court cases.
And we really need to start by validating the core premise, because before we can debunk the myths of the open road, we first have to establish that the right to travel is a very real, very powerful constitutional doctrine.
Right. It just isn't what the internet legal forums think it is.
Exactly.
So let's ground this. The memo points us directly to a landmark 1999 Supreme Court case called Saenz v. Roe.
Yes, Saenz v. Roe.
Walk us through what happened here, because this isn't a case about traffic stops at all, is it?
Not even close, no. Saenz v. Roe is the modern anchor for the right to travel doctrine, and it actually dealt with the welfare system.
Oh, interesting.
Yeah, specifically, California was trying to limit welfare benefits for certain newly arrived residents during their first year living in the state. The California law basically said, well, if you just moved here, we will only give you the level of benefits you would have received in the state you just moved from, not the higher California level.
Which feels intuitively like a penalty for moving. I mean, you cross the border, you decide to make California your home, but the state treats you like a second-class citizen for 12 months.
Precisely the issue.
Yeah.
And the Supreme Court held that this law was unconstitutional.
Right.
But what makes Saenz so historically critical is that the court used the opportunity to formally identify, define and organize the right to travel into three very specific, distinct components.
It gives the modern framework.
Yes, exactly.
So let's dive into those components, because this is the bedrock we need to understand everything else. Component number one is the literal right of movement, the right to physically enter and leave another state.
This is the most intuitive part of the doctrine. You can cross the border from Texas into Oklahoma, and neither state can put up a physical wall or, deploy armed guards to turn you back.
Or charge you an exit fee just for the privilege of leaving.
Right. You have an absolute right to use the ordinary channels of interstate passage.
Which brings us to the second component, the right to be treated as a welcome visitor while temporarily present in another state.
Yes.
The memo notes this is legally rooted in Article 4, Section 2 of the Constitution, which is the Privileges and Immunities Clause. How does that practically work? Like, if I live in New York and I take a week-long vacation to Florida, Florida can't treat me like a hostile alien.
That is the essence of it, yeah.
Mm-hmm.
This component prevents a state from discriminating against non-residents concerning fundamental privileges.
Okay, fundamental privileges.
Now, it is important to clarify that this does not mean Florida has to treat you exactly the same as a resident in every single conceivable way.
Like what?
For example, charging out-of-state tuition at a public university is a recognized legal distinction. You don't pay Florida taxes, so you don't get the subsidized tuition.
Oh, that makes sense.
But when it comes to fundamental rights, like your ability to access the Florida court system, or your right to buy and own property in Florida, or even your right to pursue a common calling or get a job while you are there, you are constitutionally protected as a welcome visitor.
Okay, I get it. You get the fundamental protections, but not necessarily the taxpayer-funded perks.
Exactly.
Then we hit the third component from Saenz, which covers what happens when you stop being a visitor and decide to stay. This is the right of a newly arrived citizen to be treated equally with other citizens of that new state once bona fide residence is established.
Yes, and Saenz located this specific protection in the 14th Amendment's Privileges or Immunities Clause.
Okay.
This third component is what strikes down laws that try to treat new residents differently from long-term residents. If you move to California with the intent to stay, you are a Californian, full stop.
So the state cannot say, well, you haven't been here long enough to earn full citizenship rights.
Exactly, they cannot say that.
So that three-part framework movement, temporary visitation and permanent relocation, is the modern law. But the memo goes deep into the historical context to show how we actually arrived at Saenz.
Right, because it wasn't always that clear.
Yeah, because in the early days, states weren't just tinkering with welfare waiting periods. They were literally trying to lock down their borders.
The historical evolution is fascinating and, frankly, a bit dark. We have to look at how states historically tried to stop human movement during times of crisis.
Like the Great Depression.
Yes. The clearest example is the 1941 case, Edwards v. California.
I read the notes on this one and it blew my mind. We were talking about the Dust Bowl era, right? California literally criminalized the act of bringing poor people across state lines.
Yes, the so-called anti-Okie law. During the Great Depression, massive numbers of impoverished Americans were migrating west seeking work.
Sure.
And California, feeling economically overwhelmed, passed a law making it a misdemeanor to bring an indigent person into the state.
That is just wild to think about today.
Right. So Mr. Edwards, who was a resident of California, drove to Texas, picked up his brother-in-law, who was out of work and had no money, and drove him back to California.
And what happened?
Edwards was arrested, prosecuted, and convicted simply for transporting a poor relative across the state line.
That is staggering. It is a literal physical barrier to migration based entirely on a person's bank account.
And the Supreme Court struck it down unanimously. Edwards stands for the profound proposition that a state may not erect physical or legal barriers against the interstate movement of persons, regardless of their economic status.
Wow.
The court made it clear that the United States is a single economic and social unit. You cannot isolate yourself from the shared struggles of the nation by walling off your borders.
But states didn't just give up after Edwards, did they? Like, they realized they couldn't put up physical borders or arrest people for crossing the state line, so they changed tactics.
Yeah, they got sneaky.
They started using bureaucratic penalties to discourage people from moving in.
Exactly. The jurisprudence shifted because the state tactics shifted. We see this play out in a string of critical cases in the late 1960s and early 1970s.
Like the Shapiro case.
Right. In 1969, there was Shapiro v. Thompson, which struck down one-year residency requirements for basic welfare benefits.
So the states argued they were just trying to protect their budgets.
Yeah, they argued they needed to ensure people weren't moving just to get better welfare. But the court said you cannot punish newly arrived residents for having exercised their constitutional right to migrate.
And it extended way beyond welfare. The memo mentions a 1972 case, Dunn v. Blumstein, which dealt with voting.
Yes.
Tennessee had a law saying you had to live in the state for a year and the county for 3 months before you were allowed to vote.
Which the Supreme Court also struck down. Now let's look at the mechanics of why they struck it down.
Okay.
The court drew a very sharp line between a bona fide residence requirement and a durational residence requirement.
What's the difference?
A state is perfectly within its rights to demand proof that you actually live there, like, showing a lease or a utility bill before they let you vote. That is bona fide residence.
Right. Just proving you are actually a resident.
But they cannot force you to wait a year just to prove you are serious about living there. that durational wait is an unconstitutional penalty on your fundamental right to travel.
And the hits kept coming. In 1974, Memorial Hospital v. Maricopa County, Arizona tried to require a one-year county residence before someone could receive non-emergency medical care at public expense.
And again, the court viewed the denial of the basic necessities of life, in this case medical care, as a direct unconstitutional penalty on interstate migration.
Okay, let me stop you right there and play devil's advocate for a second, because I think a lot of listeners might be wondering this.
Sure, go ahead.
If this right to travel, this right to cross borders, to be a welcome visitor, to not be penalized for moving, is so fundamental to the very fabric of the United States, why isn't it explicitly written in the Bill of Rights?
That's a great question.
I mean, we have the freedom of speech, the right to bear arms, protection against unreasonable searches, all spelled out in plain English. But the memo specifically notes the Constitution does not contain a single clause that plainly says every citizen has a right to travel. Why is that?
What's fascinating here is that the founders, and later the early courts, viewed this right as so structurally fundamental to the very concept of a federal union that it was essentially assumed.
Assumed.
Yes, it was considered a pre-existing right that the Constitution was designed to protect rather than a new right the Constitution was creating.
Oh, I see. It is like gravity. You do not need to write down gravity exists in the architectural blueprints for the building to stand up. It is just the invisible force holding the whole thing together.
That is an excellent way to conceptualize it. In the 1966 case United States v. Guest, the Supreme Court stated explicitly that the constitutional right to travel from one state to another occupies a position fundamental to the concept of the federal union.
Because without it, the union doesn't exist.
Exactly. To understand why, you have to look back at the Articles of Confederation, the system we had before the Constitution. Under the Articles, states were acting almost like independent, bickering sovereign nations.
Oh, right.
They were throwing up tariffs, restricting trade, and making it difficult for citizens of one state to travel or do business in another.
It was basically 13 separate countries constantly undermining each other.
Exactly. The Constitution was drafted in large part to fix that exact problem, to create a single, unified national market and a single national citizenship.
Right.
You simply cannot have a unified country if citizens are trapped within state lines or treated as foreigners the moment they cross a river.
That makes total sense.
In fact, an even older case the memo cites, Crandall v. Nevada from 1868, illustrates this perfectly. Nevada tried to impose a tax of $1 on every person leaving the state by railroad or stagecoach.
A literal exit tax. Pay the government just to leave.
And the Supreme Court invalidated it. Their reasoning was purely structural. They argued that a citizen of the United States must be able to travel to the seat of the federal government, to access federal institutions, to participate in the national economy, and to travel between states without state obstruction.
Because if they tax you $1, what's stopping them?
Exactly. If Nevada can tax you $1 to leave, what stops them from taxing you $1,000 to leave? It would destroy the union.
Okay, so we have firmly established that crossing state borders is fundamental, structural, and practically unconditional. But that brings up a massive point of confusion online.
Oh, yes, it does.
If interstate travel is this structural gravity, how does crossing into Canada or Mexico work? Because I see people online conflating these constantly. They will cite a case about passports when they are arguing with a state trooper about a traffic stop in Ohio.
That is a major, frequent analytical error, and the memo goes out of its way to separate these two concepts. There is a hierarchy of borders in constitutional law.
Okay, let's draw that line clearly for the listener.
Interstate travel and international travel are related concepts, but the legal mechanics governing them are absolutely not identical.
So if interstate travel is a structural necessity of the Union, what exactly is international travel?
International travel is generally treated by the courts as an aspect of liberty protected by the Due Process Clause of the Fifth Amendment.
Okay.
And the Supreme Court has made it very clear that while this liberty interest is real and protected from arbitrary denial, it is highly regulable by the federal government.
How regulable? Because the memo cites a whole lineage of Cold War-era cases here.
Very regulable. It starts with Kent v. Dulles in 1958. During the height of the Red Scare, the Secretary of State refused to issue a passport to Rockwell Kent because of his alleged communist affiliations.
And the court stepped in.
Yes. The Supreme Court ruled in Kent's favor, establishing that the right to travel abroad is part of the liberty of which a citizen cannot be deprived without due process of law. They said the Secretary of State didn't have the statutory authority from Congress to deny passports based purely on political beliefs.
And that was followed by Aptheker v. Secretary of State in 1964, right? Where the court struck down a law that made it a crime for any member of a registered communist organization to even apply for a passport.
Correct.
So it sounds like there's strong protection there.
There's protection against overly broad, sweeping bans based on association. But look at the legal mechanics of what happens next.
What happened?
The very next year, in 1965, the court decides Zemel v. Rusk. In this case, a citizen wanted to travel to Cuba, but the State Department had invalidated passports for travel to Cuba due to the geopolitical crisis, and the Supreme Court upheld the restriction.
Wait, let me push back on that because that feels contradictory.
I know it does.
If the Fifth Amendment protects my fundamental liberty to travel abroad, as they just said in Kane and Aptheker, how can the State Department just unilaterally decide I can't go to Cuba? Doesn't the concept of liberty imply freedom from that exact kind of government overreach?
It is a great question, and it gets to the heart of how constitutional rights are balanced. The court in Zemel explicitly explained that just because a liberty cannot be inhibited without due process of law, that does not mean it can never be regulated under any circumstances.
So there are exceptions.
Yes. When dealing with international borders, the individual's liberty interest is weighed against the highest responsibilities of the federal government, foreign policy, and national survival. The restriction on travel to Cuba was supported by the weightiest considerations of national security.
So the mechanism here is that the federal government's duty to manage foreign affairs overrides the individual's liberty to vacation wherever they want.
Precisely. And we see this reaffirmed again and again. In Califano v. Aznavourian in 1978, the court held that federal rules that have incidental effects on international travel do not trigger the same strict scrutiny as penalties on interstate travel.
Makes sense.
And perhaps most powerfully, in Hague v. AG in 1981, the court ruled that the government could revoke the passport of a former CIA agent who was traveling abroad specifically to expose undercover U.S. intelligence officers. The court made it unequivocally clear that the right to international travel is heavily subordinate to national security and foreign policy concerns.
This highlights the massive pitfall people stumble into online. I mean, when someone quotes Kent v. Dulles talking about the grand liberty of travel, and they try to apply that quote to moving from Texas to Oklahoma, or worse, driving their car down Main Street, they are mixing up entirely different legal standards.
Exactly. The right to interstate movement is a structural mandate. It is virtually unconditional.
Yeah.
International travel is a liberty interest that is heavily conditional on foreign policy, national security, and federal regulation. You cannot swap the case law between the two.
Which brings us organically to the absolute core of this deep dive. I understand the border now. I understand that the right to move across state lines is practically sacred.
Yes.
But wait, if crossing a state border is a structural right, why do I get a ticket for doing it at 90 miles an hour? Where does the protection of movement end and the regulation of the machine begin?
That is the exact pivot point where the internet mythology completely fractures under the weight of actual law. The legal distinction between the human act of movement and the operation of heavy machinery on public highways.
The memo is incredibly clear on this. The right to travel does not mean the right to drive unregulated.
No, it does not.
And this all comes down to a legal concept called the state's police power. Can you break down what that actually means? Because it sounds like it just means, yeah, cops can do what they want, but legally, it's much broader than that.
Oh, absolutely. The term police power in constitutional law is much broader than law enforcement. It refers to the inherent sovereign authority of a state government to enact laws that protect the health, safety, welfare, and morals of its citizens.
Okay.
It is the fundamental power of a society to keep itself safe and functioning.
Let me try to map this out with an analogy. Okay. Compare it to the Second Amendment. The Constitution explicitly says you have the right to keep and bear arms. That is a fundamental right. But you do not have the right to walk into a crowded town square, blindfold yourself, and wildly fire a shotgun into the air.
Exactly.
The right to bear the arm is protected. The highly dangerous, reckless modality of using it in a way that threatens public safety is strictly regulated by the state's police power. Or, it sounds like the difference between having the constitutionally protected right to free speech and demanding you have the right to broadcast that speech using a stolen radio tower and blasting it into people's bedrooms.
That is a phenomenal analogy. The Constitution protects the core right, but it does not immunize the dangerous behavior associated with it.
Right.
Historically, the moment human beings transition from walking on foot or riding horses to operating multi-ton machines powered by combustion engines at high speeds, the courts recognized an immediate, severe threat to public safety. The modality of travel had become inherently dangerous.
And the Supreme Court did not wait around to figure this out. The memo details what I would call the 4 pillars of highway regulation.
Yes, these are crucial.
These are 4 key Supreme Court cases that entirely dismantle the driving is unregulated travel myth. Let's really explore the narrative of these cases. The baseline is set way back in 1915 with Hendrick v. Maryland.
Right, 1915.
What was happening on the roads in 1915 that forced the court's hand?
You have to picture the era. In 1915, the automobile was still a relatively new, chaotic phenomenon. Roads were largely dirt or early macadam.
Barely paved.
Right. Cars were incredibly heavy, fast compared to horse-drawn wagons, and they were tearing the roads to pieces. Furthermore, accidents were becoming frequent and deadly.
So what did Maryland do?
Maryland implemented a comprehensive statute requiring motor vehicles to be registered, requiring drivers to be licensed, and charging fees based on the horsepower of the vehicle to pay for road upkeep.
And John Hendrick, a resident of Washington, D.C., drove his car into Maryland without a Maryland registration, got arrested, and argued that the state was infringing on his right to freely move about the country.
And the Supreme Court rejected his argument completely. In Hendrick v. Maryland, the court recognized a very simple, undeniable physical reality: motor vehicles moving over highways are attended by constant and serious dangers to the public, and they are abnormally destructive to the roads themselves.
Because physics doesn't care about your constitutional rights. A 2-ton piece of metal doing 40 miles an hour is a lethal weapon if handled wrong, and it grinds the pavement to dust.
Precisely. Therefore, the court held that motor vehicles are absolutely proper subjects of state police regulation.
Right.
The state has a compelling interest in ensuring public safety by making sure drivers are competent, and a compelling interest in demanding compensation for the massive wear and tear on the roads. Crucially, the court upheld Maryland's right to apply these laws even to vehicles engaged in interstate movement.
Wait, so even if you are exercising your sacred structural right to travel between states, the moment you choose to accomplish that travel by operating a dangerous machine, you submit yourself to the safety regulations of the roads you are using.
Exactly. Which transitions us smoothly to the second pillar, Kane v. New Jersey, decided just 1 year later in 1916. This case dealt with the cross-border commuter.
Right. Because after Hendrick, people started arguing, well, I don't live in New Jersey, I'm just passing through, I am an interstate traveler, so your local state laws shouldn't apply to my vehicle.
And the Supreme Court shut that loophole down immediately. Kane extended the rule from Hendrick directly to non-residents.
So no free pass for passing through.
None at all. The legal principle established is crystal clear. Just because you're passing through a state does not mean you get to ignore the host state's safety laws.
That makes sense.
The power of the state to regulate motor vehicles on its highways extends equally to non-residents as it does to residents. A car driven by someone from New York is just as heavy and just as potentially dangerous as a car driven by someone from New Jersey.
Physics again.
Right. The state's police power covers the physical reality of the machine, regardless of the driver's zip code.
That makes perfect logical sense. Okay, the third pillar jumps forward in time to 1941, Wrights v. Mealy. This case adds a whole new dimension, because it's not just about physical safety anymore, is it?
No, it introduces the concept of financial accountability.
Yeah.
Wrights v. Mealy upheld a New York law that suspended the driver's licenses and vehicle registrations of individuals who had unsatisfied judgments arising from motor vehicle accidents.
Let me make sure I understand the mechanics of this.
Sure.
If I cause a massive car crash, and the court orders me to pay the victim $50,000 for their medical bills, but I refuse to pay it or, declare bankruptcy to avoid it, the state of New York could revoke my driver's license.
Correct. The Supreme Court recognized that the use of public highways creates immense financial dangers alongside the physical ones.
Right. Ruined cars, hospital bills.
Exactly. A bad driver can ruin a victim's life economically. Therefore, the court ruled that driver licensing is a valid constitutional tool to promote financial responsibility. The state can demand that if you're going to operate this dangerous machinery, you must be accountable for the damage you cause.
And now we arrive at the fourth pillar, which the memo notes is heavily, almost aggressively misunderstood by the internet legal community Bell v. Burson from 1971.
Yes. If you spend enough time reading forums or watching sovereign citizen videos, you will inevitably see people confidently quoting Bell v. Burson, claiming it is the ultimate proof that driving is a constitutionally protected right beyond state regulation.
But they're wrong.
They misread the case entirely.
So when people cite Bell, they think it means driving is untouchable. But reading the memo, it looks like Bell isn't about the substantive right to drive at all. It looks like it's just about the administrative process of taking a license away. Is that the disconnect?
That is exactly the disconnect. To understand Bell v. Burson, we have to explain the legal difference between a substantive right and procedural due process.
Okay, lay it out for us.
Mr. Bell was a clergyman in Georgia who was involved in an accident. Georgia had a law that said if you were in an accident, your license was automatically suspended unless you posted a security bond to cover potential damages.
Wait, automatic?
Yes, regardless of whether you were actually at fault.
So a purely administrative punishment before you even get a chance to defend yourself in court.
Right. And the Supreme Court said Georgia couldn't do that. The court held that once a state makes a driver's license important to a person's livelihood, which it obviously is for most people who need to drive to work, and allows you to keep it unless there is cause to take it away, that license becomes a protected property interest under the Due Process Clause of the 14th Amendment.
Meaning the state cannot just arbitrarily snatch it away in the dead of night.
Exactly. The ruling was about procedural due process. It means you are entitled to notice and a hearing before your license is suspended, so you can argue that you weren't at fault.
Got it.
It absolutely does not say that driving is an unregulated constitutional right. It does not say the state cannot require a license in the first place. It simply says that if the state requires one and you earn one, they have to follow fair constitutional procedures to take it away.
So what does this all mean? When we put all four pillars together, it means the right to travel protects human movement. It protects your right to relocate across borders, to seek a new life in a new state, and to not be penalized for doing so. But it does absolutely nothing to erase a state's inherent police power to govern the safe operation of dangerous machinery on shared public roads.
That is the definitive line in the sand. You have a right to travel. You do not have an unlimited, unregulable right to operate a motor vehicle free from neutral, reasonable public safety laws.
Okay, we have established the real law. We understand the foundational cases from Saenz to Hendrick. Now it is time to have a little fun.
Oh, absolutely.
It is time to step into the court of internet myths. We are going to tackle the bad arguments heard on the side of the highway every single day, and we are going to dissect exactly why they fail legally.
I am ready. Let's apply actual jurisprudence to the roadside mythology.
So picture this scenario. Someone gets pulled over for speeding. The officer walks up to the window, asks for a license, and the driver's immediate, confident response is, "I am not driving, officer. I am traveling in a private conveyance." Driving is a commercial term. What is the actual legal flaw there?
The legal flaw is relying on semantics instead of physics.
Right.
We rebut this immediately with the precedent from Hendrick v. Maryland and Kane v. New Jersey. The Supreme Court in those cases did not care about the dictionary definition of the word driving versus the word traveling.
They cared about reality.
Right. They cared about the physical reality of a heavy motor vehicle moving over a public highway. The kinetic energy, the danger to the public, and the physical damage to the infrastructure are exactly the same regardless of what vocabulary the operator chooses to use.
Yeah, the car doesn't get lighter just because you call it a conveyance.
Exactly. The claim that automobile travel is magically immune from licensing just because you call it a private conveyance is entirely defeated by over a century of settled Supreme Court precedent.
I love that. Physics doesn't care about your vocabulary. Okay, let's look at another common roadside scenario. The driver rolls down the window and says, "Look, I am not hauling freight for money. I am not engaged in commerce. Therefore, the state traffic codes, which are commercial codes, do not apply to me."
This represents a fundamental, massive misunderstanding of where state power comes from. States do not regulate traffic solely under their authority to regulate commercial law or the Uniform Commercial Code.
So it's not about commerce at all.
No. They regulate motor vehicles under their general police power, which we discussed earlier, the power to protect public health and safety.
Right.
When a state mandates speed limits or requires working brake lights or mandates stopping at red lights, it is acting to prevent injuries and fatalities, not just regulating interstate commerce. Traffic laws apply uniformly to everyone operating a vehicle, commercial or private, because a private family sedan blowing through a red light at 60 miles an hour is just as deadly as a commercial freight truck doing the same thing.
Right. A pedestrian doesn't care if the car hitting them is commercial or private. Safety is safety.
Exactly.
Here is another one that pops up constantly. The driver argues, the Supreme Court has explicitly said driving is a fundamental liberty and a right, not a privilege. Therefore, no traffic laws can apply to me.
If we connect this to the bigger picture, the analytical flaw here is assuming that rights cannot be regulated. Let's return to your excellent Second Amendment analogy or look at the First Amendment.
Right, the soundtrack at 3 a.m.
Yes. Even fundamental enumerated rights are subject to reasonable time, place, and manner restrictions. You have freedom of speech, but you can't use a sound truck to blast your manifesto through a residential neighborhood at 3 a.m.
That makes total sense.
But more importantly, operating a motor vehicle has long been explicitly classified by the courts as a highly regulable activity due to its inherent danger. You have a fundamental right to travel. You do not have a fundamental right to drive a 2-ton machine at 90 miles an hour through a school zone.
What about the jurisdictional argument? You see videos where the driver states, because I have a constitutional right to travel, you, the police officer, have no jurisdiction to detain me or stop my vehicle.
The right to travel offers zero immunity from lawful traffic stops under the Fourth Amendment.
Zero.
Zero. If a law enforcement officer has reasonable suspicion or probable cause to believe that a traffic violation or a crime has occurred, for example, if they visually observe you speeding or running a stop sign, they have the absolute constitutional authority to stop the vehicle.
So seeing you break a safety rule is all they need.
Exactly. Similarly, if they are conducting a sobriety checkpoint that satisfies Fourth Amendment standards, they have jurisdiction. Your broad constitutional right to eventually reach your destination tomorrow does not override the officer's legal duty to enforce safety laws in the present moment.
Let's talk about the money argument, because I think this one actually resonates with regular people who aren't even sovereign citizens.
Oh, for sure.
If you're listening to this and thinking, look, I pay income taxes, I pay property taxes, my taxes built these roads, why do I have to pay the state a registration fee every year just to put my car on the road? Isn't that an unconstitutional tax on my right to travel?
It is a fair question, and it requires us to contrast two cases we discussed earlier.
Okay, let's go.
In Crandall v. Nevada, remember, the Supreme Court struck down an illegal exit tax fee charged simply for the physical act of leaving the state. That is unconstitutional because it taxes the movement itself.
Right, taxing human movement.
But in Hendrick v. Maryland, the court explicitly upheld vehicle registration fees. Why? Because the court recognized that vehicle registration fees are not taxes on the human act of moving. They are user fees and regulatory fees designed specifically to compensate the state for the massive cost of maintaining the paved roads and administering the safety system.
Because cars wear down the roads, but pedestrians don't.
Exactly. If you choose to exercise your right to travel by walking, riding a bicycle, or taking a commercial bus, you personally do not pay a vehicle registration fee.
That's a great point.
You only pay that fee if you choose to utilize the highly regulated, expensive public infrastructure with your own heavy machinery. You are paying for the damage you cause and the administrative overhead of keeping you safe.
And finally, let's look at the myth regarding residency. The argument is, the right to travel means no state residence requirements are valid. The state can't make me prove I live here for anything, whether it's voting, getting a driver's license, or buying a gun.
This myth fails because it entirely ignores the nuance we discussed in Dunke-Blumstein.
The bona fide versus durational thing.
Yes. The Supreme Court drew a sharp, clear line between bona fide residence requirements and durational penalties. A bona fide residence requirement, meaning the state asks you to prove you actually live there by showing a utility bill or a lease agreement before you register to vote or get an in-state license, is perfectly legal and universally utilized.
And the durational one is the bad one.
Exactly. What is illegal is a durational penalty, acknowledging that you live there, but making you wait a year before you get access to basic civic participation.
So when we strip it all away, all of these internet myths, every single one of them, rely on the exact same fundamental legal fallacy.
Yes,
Yeah.
they all collapse the fundamental constitutional right of human relocation and movement into the highly regulated, state-granted privilege of operating a motor vehicle on public infrastructure.
They confuse the human with the machine.
They intentionally confuse the human with the machine. Once you separate the human movement from the machine operation, the entire pseudo-legal framework simply evaporates.
Which is exactly why this memo provides what it calls the ultimate analytical framework.
And it is so useful.
It really is. Let's put this all together into a practical toolkit. If I'm a lawyer or just a listener trying to parse a news article about a new travel law, how do I actually map this out without just vaguely yelling Constitution into the void? The memo gives a 7-step mental model, and I want to weave through it. The very first thing you have to do is identify the exact type of travel happening, right?
Correct. You cannot analyze the law until you know the facts. Is the person engaging in interstate travel simply crossing a border?
Or a temporary visitor.
Right. Are they asserting their rights as a temporary welcome visitor?
Mm-hmm.
Are they migrating permanently to become a new citizen of a state? Are they attempting international travel across a national border? Or are they simply operating a motor vehicle on a public highway?
Because the rules change for each one.
As we have learned over the last hour, entirely different sets of constitutional rules apply to each of those distinct categories.
Once you know what kind of travel it is, you look at the government actor. Who is actually imposing the rule? Because the rules change if it's the feds versus the state.
Absolutely. The source of the restriction fundamentally alters the constitutional analysis. If the federal government is restricting a passport, you are looking at Fifth Amendment liberty and foreign policy.
And if it's the state?
If a state government is requiring a driver's license, you are looking at 10th Amendment police powers and public safety. If a local municipality is putting up a toll booth, you are looking at user fees.
Then you have to identify the legal burden. What is the law actually doing to the person? Is it a physical block like California criminalizing bringing poor people into the state in Edwards?
Or a tax.
Right. Is it an unconstitutional exit tax like Crandall? Is it a durational penalty on basic benefits like Saenz? Or is it just a simple neutral safety rule like requiring working brake lights?
And identifying that burden naturally leads you to locate the constitutional source of the protection. Are we relying on the Article 4 Privileges and Immunities Clause for a temporary visitor?
Or the 14th Amendment for a new resident?
Yes. Or the Fifth Amendment for an international traveler?
Which brings us to the actual mechanics of the courtroom, the standard of review. How heavily is the judge going to scrutinize the law?
This is where cases are won or lost. If a state passes a law that acts as a penalty on interstate migration like withholding welfare or medical care, the court will apply strict scrutiny.
Which is tough to beat.
Strict scrutiny is the highest, most difficult standard in constitutional law. The state must prove it has a compelling, vital interest and that the law is narrowly tailored to achieve that interest without unnecessarily burdening the right. Laws rarely survive strict scrutiny.
But traffic laws are different.
Very different. If the law is just a standard highway regulation like a speed limit, the court will apply police power reasonableness. They will ask, is this law rationally related to a legitimate government interest in public safety? Almost all traffic laws easily pass this test.
The critical pivot in this whole mental model is distinguishing travel from driving. If the case involves a car, you have to stop and ask, is this person actually being stopped from entering or leaving the state? Or are they simply being required to comply with a neutral, uniform vehicle regulation tied to safety and accountability?
And once you answer that, you apply the exact authority. The memo explicitly warns against the lazy habit of just throwing around general right to travel language.
You have to be specific.
You have to use the right legal tool for the specific job. You use Saenz when arguing about equal citizenship and welfare. You use Hendrick and Kane when dealing with motor vehicle regulations.
And Kent for passports.
Exactly. You use Kent and Hague for international passports. This framework forces legal precision. It stops the mixing and matching of unrelated cases to create a false mythological narrative.
Here's where it gets really interesting. When you look at this entire analytical lens, you realize that the question people in these viral videos are asking is fundamentally flawed.
Oh, completely flawed.
The question is almost never, do I have a right to travel? Of course you do. The correct legal question, the only one that actually matters in a courtroom is this specific law an unconstitutional burden on human movement? Or is it a neutral, reasonable safety regulation of a dangerous activity?
That is the synthesis of the entire memorandum. The right to travel is a massive, real, structural right. It ensures we are a single, unified nation where citizens can move freely, seek new opportunities, escape economic hardship, and be treated equally when they relocate to a new state.
It's beautiful, really.
It is a profound liberty. But it does absolutely nothing to protect you from neutral, reasonable public safety regulations regarding the operation of motor vehicles.
The advice at the very end of Dynamo Jack's memo is brilliant in its blunt simplicity. Bring law, not slogans.
I love that quote.
Yelling internet catchphrases at a police officer through a cracked window during a traffic stop is not going to save you. It will probably just escalate the situation and get your window broken.
Yeah, that rarely ends well.
But truly understanding constitutional case law, knowing the profound historical difference between Saenz v. Roe and Hendrick v. Maryland, that is actual, actionable intellectual power.
It is the difference between reciting a magical incantation you found on a forum and actually understanding the deep architecture of the American legal system. But, if I may, as we wrap up this deep dive, the material raises an incredible question for the future, one that builds directly on everything we've just discussed regarding the distinction between human movement and machine operation.
Oh, I like where this is going. What is the question?
Everything we have discussed for the past hour, from Hendrick in 1915 to the modern traffic stop, relies on a single foundational premise: that a human being is actively operating a dangerous piece of heavy machinery.
They are the driver.
Right. Their reflexes, their attention, and their competence are what keep the public safe. But as we move rapidly into an era of fully autonomous, self-driving vehicles, the human inside the car will eventually be nothing more than a passive passenger.
Oh, wow.
They won't have a steering wheel, they will just be traveling.
Whoa. That is wild to think about.
If the human is no longer operating the dangerous machinery, if the artificial intelligence is entirely responsible for the driving, how might these long-established legal lines begin to blur?
Right, because they're not driving anymore.
Exactly. Does the state's police power over driver licensing start to recede? If you are not driving, do you even need a driver's license to sit in an autonomous pod that crosses state lines?
Man.
Does the fundamental right to travel suddenly expand back into the vehicle space, overriding motor vehicle codes, simply because the human is merely being transported?
That is incredible. We spent all this time establishing that the law separates the human from the machine, but the X-ray machine of the law is going to get murky all over again when the technology permanently blurs the definition of operator.
We might need a whole new set of Supreme Court pillars for the AI era.
It is definitely something for all of you to ponder as the nature of travel and the nature of driving continues to evolve.
Absolutely.
Well, on that provocative note, we are going to leave you to mull over the autonomous future of the open road. Thank you for joining us on this deep dive into the constitutional realities of travel. Until next time, keep questioning, keep learning, and maybe double-check your vehicle registration.
We question everything they taught you, because the comfortable lie is the most dangerous one.